just to show that you are trying to project Mahadev online app as something which is like a dragon, and you are saying everybody who's involved with the Mahadev app is an accused, you have to establish something. ED finds 100 crores of cash somewhere. Their job is to inform the authorities so that authorities can investigate. Dream 11 is one of the app which is promoted by the Indian cricket team. If you are saying Mahadev app is illegal, why there are more than 100 apps which are working in the country today? That running Mahadev online book app is not a scheduled offense, which they have admitted in their reply. They are saying that Mahadev app is not illegal in terms of scheduled offense.
Yes.
Because the Lottery Act, which Betting Act, my lord, Betting Act is not a scheduled offense. So what they have done is, my lord, their allegation, which they have now clarified in the reply, is very, very important. They said, yes, Mahadev app is not an offense which can result into money laundering. But they have gone one step further by saying that in India, there are some unauthorized bank accounts which have been opened. Some bogus bank accounts have been opened. That amounts to cheating and forgery. So therefore, that is a scheduled offense.
Yes.
Now, my lord, before I come on to the facts, may I just, my lord, request this honorable court to just mark their, because since they have clarified it now, it's my duty, my lord, to tell this honorable court and see what exactly they are saying at page 11 of the reply. Very, very important. Then, my lord, I'll be able to crystallize my submission. My lord, when in my bail application, I challenge this aspect.
Page 11 of the reply.
11 of the reply, my lord. The pagination is on the top.
The reply has been filed on 13/6.
Yes, yes, my lord. Same reply. My lord, the reply is running into 24 pages only, and then there are
Page 11.
anecdotes. Page 11. My lord.
Para B.
My lord, this is reply to grounds. In the middle, my lord would find reply to grounds. Usme agar aap, in case my lord would come to 11, they have replied to my grounds, because this is one of my ground.
6.5.
Yes, yes. Please see in the bottom reply to 6.4 and 6.5. Averment made in the para are vehemently denied. ED in its prosecution complaint file has clearly identified the proceeds of crime and its utilization by the betting syndicate. Now, next line is important. While it is accurate that Public Gambling Chhattisgarh Amendment Act is not classified as scheduled offense under PMLA, it is pertinent to note that proceeds in question were being generated by Mahadev online book through various bogus and Benami bank accounts. The predicate agency has incorporated relevant sections of the IPC, which are indeed scheduled offenses under the PMLA. My friend is getting... That's why I'm reading, sir. The predicate agency has incorporated relevant sections of the IPC, which are indeed scheduled offense under PMLA, to address the criminal activity of opening bogus Benami bank accounts and utilizing them for illegal online betting.
Yes.
They have crystallized their allegation. Last three lines are very, very important, my lord. Thus, as per PMLA, illegal funds belonging to Mahadev online book being transferred through the bogus Benami bank account is nothing but proceeds of crime in terms of 21U of PMLA. Please mark this very, very carefully, my lord. This will be the game changer in this entire case, which is being investigated by the state. This, according to me, has changed the entire complexion of their investigation, because they have accepted our argument that Mahadev per se is not a scheduled offense. Therefore, you have confined your investigation only to the forgery and cheating in the bank accounts. Now, my lord, who will investigate this? The jurisdictional police. In this entire prosecution complaint which they have filed, no bank account mentioned, no forgery mentioned, no cheating mentioned, no reference of any of these scheduled offenses have been mentioned in this case, my lord. Now, please come to the definition of 21U and section 3. Please permit me to read section 3 and then straight away come on to the definition of 21U. But this is the scheme of Money Laundering Act, which I am reading.
Section 3.
Section 3, my lord. May I read, my lord?
Yes.
Whoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition or use, and projecting or claiming it as untainted property, shall be guilty of offense of money laundering. Then, my lord, explanation was introduced somewhere in 2019, which says, for the removal of doubt, it is hereby clarified that a person shall be guilty of offense of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in any one or more of the following process or activity connected with proceeds of crime, namely concealment, possession, acquisition, use, projecting, or claiming. Now, my lord, I'll just pause here for a moment. Now, my lord, what is Section 3? Section 3 says there has to be a criminal activity which is connected with the scheduled offense. If you commit that and generate some money, that becomes proceeds of crime, which will be clarified from the definition of 21U. Please see 21U, then I'll, my lord, try to give an interpretation for the kind consideration of this court. Proceeds of crime means, my lord, has 21U, just on the left page.
Yes.
Proceeds of crime. Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or the value of any such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. Explanation. For the removal of doubt, it is hereby clarified that proceeds of crime include property not only derived or obtained from scheduled offense, but also any property which may directly or indirectly be derived or obtained as a result of any criminal activity relatable to the scheduled offense. So, my lord, anybody, so there are, my lord, two boxes. First is scheduled offense, generation of money, which is termed as tainted money. So, when the tainted money is converted into untainted money, that process is called money laundering. So, Honorable Supreme Court in many, even in Vijay Madan Lal says, the sine qua non is existence of scheduled offense and existence of proceeds of crime generated from the scheduled offense. So therefore, that is very, very compulsory. That is why my lord would find the moment there's an acquittal or discharge or quashing of scheduled offense, the entire case goes. Even recently, I think in one of the local cases with regard to alcohol extortion, one Mr. Sunil Agarwal in the coal case, he was granted bail by Honorable Supreme Court about a month back. We appeared in that, where, my lord, there was no scheduled offense. The scheduled offense was noted in FIR, but charge sheet was not filed. So Honorable Supreme Court asked, where is the scheduled offense? They said, no, we have to file charge sheet. When will you file charge sheet? We don't know. So bail is granted. Now, my lord, please read 321U and now para 11, which they have mentioned in the reply. If we sync all three of them, my lord, their case is, yes, Mahadev app is not a scheduled offense, but opening of a bank account is a scheduled offense. So money generated in terms of 21U is money generated from that account.
It's a simple
Because
case
that
of
is forgery, my lord. That is forgery. So if you are saying that is a scheduled offense, where is the proceeds of crime generated from that account? Your prosecution complaint should identify that. If you are unable to identify proceeds of crime, how do you say that proceeds of crime, my lord, which is concealed, possessed, acquired, used, or projected or claimed by someone? The allegation against me is I have received proceeds of crime. Now, they have not even identified proceeds of crime. Well, Lord, it is very, very significant. I'm trying to make it as simple as possible, my lord, just to show that you are trying to project Mahadev online app as something which is like a dragon. And you are saying everybody who's involved with the Mahadev app is an accused. You have to establish something in terms of money laundering. But I am not justifying Mahadev app here. We are interpreting the law. They may be violating something. Millard Vijay Madan Lal says in one of the paragraphs that if ED finds 100 crores of cash somewhere, their job is to inform the authorities so that authorities can investigate and see what is the violation. Suppose it's an income tax violation, unaccounted money, that's not scheduled offense. So therefore, you can't have, ED cannot have jurisdiction unless and until it is established that 100 crores which ED has recovered in a raid is connected with some crime, which is a scheduled offense. So scheduled offense becomes sine qua non. So by saying Mahadev app is not a scheduled offense, which you have admitted now. So, my lord, coming back onto the allegations. Now, please see how I am involved. I am, my lord, involved in the second prosecution complaint. And before that, my lord, let me read the first one to this honorable court so that my lord will have a hang of what exactly the allegations are, page 92 onwards. My lord, I will start with only the relevant paragraphs, since I have already tried to, in nutshell, my lord, inform the court about the facts of the case, but my lord, may only note it down so that I will not waste time, my lord. Immediately after the cause title, where the accused names are mentioned, please straight away come as to what are the FIRs involved. At page number 96, bottom, there is a table A which talks about the scheduled offenses.
Yes.
My lord would find it at 96.
Yes.
The heading is FIR complaint, police report under 173 of CRPC of scheduled offenses. Well, these are all scheduled offenses.
Yes.
157/22 is a final report in FIR number 112. And my lord may see next page. Only FIRs are mentioned. FIR 206, then FIR 37 at serial number 3, then 152 at serial number 4, 336 at serial number 3. These are all Chhattisgarh FIRs. And then my lord would see at 98 top, 685, there's a FIR registered by Chhattisgarh Police. And then my lord, there are some 2.1 is the final report.
Yes.
Now please see the allegations here. Final report bearing, my lord, has this 2.1?
Yes.
Yes. Final report bearing number 157 or 22 was filed by Chhattisgarh Police against so-and-so under 120B and 420 for being involved in online betting in live Ludo football casino games and marks through Mahadev book. The charge sheet was filed in FIR number so-and-so as per charge sheet filed by so-and-so. Now, a raid is conducted, accused persons are interrogated, laptop, mobile phones are recovered, my lord.
Yes.
They have now clarified that this is not a scheduled offense. Please see, my lord, FIR number 206. Also, they are running a call center. This was all, my lord, initial investigation. They have crystallized it now. In the beginning, you arrest, you register, you take anybody in custody. The moment they are tested in the court of law, then the clarification comes. So these are all, these are the basis for triggering the investigation. So all these FIRs, my lord, would find, which they have registered, and they started investigation at page 102.
Yes.
Page 4.1. ED has conducted a detailed investigation across multiple states and has deciphered the modus operandi of the predicate offense and the offense of money laundering, which is being done by Mahadev online book and its promoters. ED findings reveal that tentacles of this online betting and money laundering racket have spread far and wide. FIRs have been registered across the country, and the system of franchising panels has spread to the entire country and abroad. Criminality stems from the fact that many of these betting activities are not permissible activities, although they are not scheduled offenses. Benami bank accounts are being used to receive and to pay money to the players. All these transactions are not accounted and are not brought into the tax net. Hawala channels are being used to move the funds across international borders. Promoters who are natives of Chhattisgarh have comfortably parked themselves out of India and created assets of themselves across the globe, but they still rely on the links back in Chhattisgarh to have a steady supply of arms to so-and-so, so-and-so. Then, my lord, Mahadev book is defined in the bottom. Mahadev online book provides online platform for illegal betting in different live games like poker, card games, chance game, betting on so-and-so, so-and-so. And all this is mentioned on the next page again, my lord. These are the advertisements which used to be given. Then, my lord, few pages down the line, the background of promoter at page 106. Interestingly, my lord, there are many apps like Mahadev apps which are working in the country even today. Dream 11 is one of the app which is promoted by the Indian cricket team. If you are saying Mahadev app is illegal, why there are more than 100 apps which are working in the country today? Now, my lord, all those apps, now Mahadev app at one point of time was working, my lord, there was ads all around. If one person, because it is allowed by the government, if one person deals with the app, say in 2021, and now after the registration of FIR, you call him, you say you used to deal with Mahadev app. You are an accused in this case. Well, the knowledge of a criminal activity, mens rea, is an essential ingredient even in this case. Section 3. That's why the word uses knowingly. If I knowingly indulge in the proceeds of crime, knowing that it's a crime, it is not proceeds of crime. 420, etc. were invoked, were brought into the act only in 2009. That is why ECIR on the basis of 420 of prior to 2009 are being quashed, because at that point of time, it was not a scheduled offense. So you yourself permit these kind of apps to function in the country. When people involve themselves in the app, down the line after 10 years, you arrest them. Why have you? They were not aware. It was the job of the administration and the government to make sure that these apps do not function. If they are functioning, and will all those people, those who are participating, my lord, would be shocked to know not even a single player or a person who's playing in the app is a victim in this case. No complainant, no one has said that I have been cheated. No one says I have been cheated. Unilaterally, the government, the enforcement director says it's an illegal activity, although it is not a scheduled activity. I have every right to investigate. I will arrest each and every person who's involved in Mahadev app.
Yes.
Now, please see the background. Mahadev app began in operation in 2019-20, but its reach among users saw a huge increase during COVID pandemic 2020 and continued to grow up since Mahadev book is controlled and beneficially owned by Saurabh Chandrakar and Ravi Uppal, who hail from Bhilai, Chhattisgarh.
Where you are reading?
Well, I'm reading 106 at bottom.
106.
Yes.
So
106 pe sir, this is the prosecution complaint.
no, this is something else in my.
No, this is 106 of that compilation. I'm reading the prosecution complaint. वो सर ये होगा सर
इसमें
additional law. I was reading, my lord, the complaint which they have filed. They have described what is Mahadev app. I started reading, my lord, from 92 onwards. So, my lord, this is brief background of promoters of Mahadev book and their close associates presently based out of India. Mahadev app began its operation in 1920, but its reach among users saw a huge increase during COVID pandemic 2020 and continued to grow up since then. Mahadev book is controlled and beneficially owned by Saurabh and Ravi. Now, please see in the last two lines. The associates like Mr. Vikash Chhapadia. So I am linked with him. The associates like Mr. Vikash Chhapadia, who too reside in UAE, help the owners in handling these betting proceeds and further launder them by investing in assets or otherwise. There are associates to manage accounts, associates to oversee how a panel caters to player, punter, associates to collect funds from multiple branches, so and so. Saurabh and Ravi have established a well-trained workforce to manage the complex transaction involved in their betting. Thousands of workers have been employed by Saurabh and Ravi. Majority of this workforce belong to Bhilai. Workforce is colloquially referred to as checkers because their main responsibility is to monitor the accounts of betting panels, so and so, so and so. Then my lord may see in the bottom, panels and branches. They are saying that they have various panels and branches, my lord. This is the modus operandi, how they function and how they share the profit to them. My lord, may skip this for a moment and come to internal page 15, 110, my lord.
Yes.
Brief of illegal nexus. It is not out of place to mention that although Mahadev online book is running across India and even in foreign countries, it has deep roots links with Chhattisgarh. Apart from the fact that two main accused are from Chhattisgarh, it is seen that most of the panel so far raided by ED are being run by old associates, Ravi and Saurabh. It is learned that many semi-educated youths of their native districts have moved in large numbers to Gulf, even during marriage. Now, this is a lot important. Even during marriage ceremony of Saurabh has established a large number of natives of Chhattisgarh was taken to Rasul Khema via 3 chartered planes from Nagpur. The main accused persons rely on trust reposed by local here. Most of the panels being run in far-flung Dehradun, Punjab, etc. were also found to be employing youths from Chhattisgarh. In this context, it is imperative for the promoters to have smooth liaison with the local state machinery. Their network of bookie, Benami, shell, bank accounts, and huge banking transactions cannot operate uninterruptedly without political patronage. During the course of investigation, ED arrested and accused Chandrabhushan Verma. He is at ASI, accused number 4, which I had mentioned. Assistant Sub-Inspector for his significant role in liaising with police and politicians on behalf of promoter of Mahadev book app in the state of Chhattisgarh against payment and handling of such money originating from coffers of Mahadev online. Chandrabhushan Verma ASA became the main link between the accused-based promoter and the power to be in Chhattisgarh to ensure smooth operation. Well, just one footnote here, not even a single person nominated among the police machinery or politician till date. So you have arrested ASI, making an allegation, he's liaising with someone. Who are those people? We don't know. Next two names, my lord. ED investigation revealed the role of Anil Kumar Damani and Sunil Kumar Damani in this flow of Hawala funds from Mahadev app to ASI Chandrabhushan. Investigation conducted revealed that Damani brothers used to receive funds originating from illegal online business and knowingly routed the same to ASI for distribution among the police officers and politicians. That for their role, Anil Kumar Damani, Sunil Kumar Damani were arrested. These findings regarding payment of licensing money was also confirmed by Satish Chandrasekhar and other panel operators, so and so, so and so. Now, next page, 2-3 pages are Well, the next few pages are only those functions which happened, my lord. And then, my lord, page 114, how it all worked. Then 115. Well, the relevant, now I straight away come on to the paragraph which linked the petitioner at page 119. Here, my lord, my role comes. And this is, my lord, the first prosecution complaint where I have said that I was treated as a witness because my statements were relied upon to prosecute
Yes.
Vikash Chhapriya. Searches on 8/9/23. This, my lord, is after 1 year of registration of ECIR. Searches on 8/9/23 were conducted at the premises of Vikash Chhapriya in Kolkata, who handled all the Hawala-related operations for Mahadev app for marriage-related payment. ED conducted searches at his known premises and at his associates like Govind Kedia and Amit Sarogi. My lord, may just mark these two names. The search action led to discovery of 3 companies beneficially owned by Vikash Chhapriya and which were investing in India through foreign portfolio investment route. Accordingly, cash derivatives and other security holding valued at 236.3 crores of Perfect Plan Investment LLP, Exim General Trading FZCO, and Messrs TechPro IT Solution LLC. My lord, may also mark TechPro. They are linking me with this company. Were frozen under section 17(1)(a) under the reasonable belief that these funds are originating out of coffers of Mahadev online book. That Vikash Chhapriya was also found to be investing in Indian share market in his name and company name Lexis Residency LLP. In the name of Vikash Chhapriya, 6 crore was found, and in the name of Lexis Residency, assets worth 30 crores were found. NSDL and CSDL holding along with bank accounts in respect of so and so. Search at the residence of Govind Kedia on 8/9/23 led to seizure of his personal laptop and details of client ID which were being shared by him with Vikash Chhapriya. Further, as per digital records seized from Govind Kedia, he was found to be in touch with Vikash Chhapriya. Vikash Chhapriya is A3 over WhatsApp as well.
He is the same person who has paid certain
Yes,
amounts to the
Well,
vendors.
all that will come now.
Yes.
Over WhatsApp as well. He was sharing some Excel account statements. Though the Excel file was found to be deleted, but similar names files were found in the laptop of Govind Kedia. And when analyzed, following names appeared: Lexus Residency, Vikash Chhapriya. C is Nitin Tebriwal. Please mark this. So when Govind Kedia's place was searched, some documents with regard to Nitin Tebriwal, his name also appeared
In his laptop.
in his laptop, my lord. So as of now, I have no role to play. Now, first time my name appeared after 1 year of investigation. And then my lord would see. Subsequently, his office premises was also searched. During the search, all the holding associated with following demat accounts associated with PAN of Govind Kedia, his family members and companies as follow, were frozen in freezing order under so-and-so.
Yes.
Now, this is all with regard to Kedia. Please turn the page. These are most important pages, my lord, next 1 or 2, where they are linking me with this entire thing. As per the own admission of Govind Kumar Kedia, the securities holding linked with the above PAN totally stands at 197 crores as on 31/3/23. Govind Kedia was further investigated. It is admitted by him that he is investing huge amount of capital in shares as per the instruction of Vikash Chhapriya. So, my lord, his statement says, yes, whatever I am doing along with him. And in the name of Vikas's friend, he claimed that there is no written agreement between him and Vikash Chhapriya or his friends to guide these investments, and any profit or loss incurred in purchase and sale of these shares would be shared at 75-25 ratio. He also claimed that he charges interest on only 25% of total amount invested in shares. As per his claim, he has kept no security for any unexpected result in share market, as he has the belief that Vikash Chhapriya shall oblige and pay in case of any major loss. However, records seized from his premises when analyzed revealed that interest was being charged on complete amount invested in shares. Moreover, there is no financial rationale of this kind of investment, that it does not have any control on nature of share market, which is renowned to throw unexpected results. Neither he can foresee persons sitting in Dubai to pay any dues while being in India. Thus, it is suspected that he is handling cash for Vikash Chhapriya and his friend. Well, at a footnote here that Govind Kumar Kedia is not an accused in this case. The biggest question mark is he is neither shown as an accused nor a witness till date. Please see the date of search 8/9/2023, where there's an admission and they say that it is suspected that he was handling cash for Vikash Chhapriya. Cash was the security on the back of which he is doing Benami share market investments using his own capital, and he would deduct any profit or loss from the cash available with him. Mr. Vikash Chhapriya has been summoned twice but did not appear. Mr. Govind Kedia, during his statement, revealed he was in knowledge of the fact that sudden riches of Vikas Chabdia is nothing but from his association with Mahadev app. Thus, in a way, Govind Kedia was investing cash funds of Vikas Chabdia in India share market, knowing fully well that Vikas was in possession of proceeds of crime. Thus, he is becoming a willing associate of Vikas Chabdia to invest in stock, even though Vikas Chabdia does not have account capital. Thus, he is assisting Vikas in acquiring further derived profit. Therefore, the capital of Govind Kedia, which is invested in stocks as per instruction of Vikas, is tainted and is under suspicion. Thus, it is liable to be frozen till Vikas Chabdia responds to ED summons and gives an alternate explanation for his business and wealth. See, my lord, the presumption. There is no link of Vikash Chabdia with the Mahadev app. Only a presumption. Let's presume that they have presumed as far as Vikash Chabdia is concerned.
Yes.
Now, Vikash Chabdia, if he's dealing along with Mr. Govind Kedia or somebody else, my lord, they are presuming, yes, you also must be dealing in tainted till he comes. So, last two lines are important. Till he comes, joins, and he explains that this money is not proceeds of crime. Please read this with page 11 of the reply now. Mahadev app per se is not an illegal activity covered in scheduled offense. So entire investigation report earlier was presuming Mahadev app is a scheduled offense, which is not. You yourself now have crystallized. We are talking about those bank accounts which have been opened. Which are those bank accounts? How much amount was credited? Because 2-1 says the money derived from that scheduled offense, that criminal activity is false bank accounts. They have to show the bank accounts. They have to calculate the proceeds of crime. Now, if that proceeds of crime comes into our account, only then we will be accused. Well, not we are dealing with a statute, number one. We are dealing with the liberty of an individual. That is why, my lord, making a case is very easy. You take an 8 of section 45 that you have to show that it is not a scheduled offense, you are not guilty of an offense, only then you will be granted bail. But you will not even prima facie show. You will not satisfy section 3 and 2-1U. 2-1U 3 is not even remotely prima facie established in this entire case. That is why, my lord, when I read the reply last night, I was at least happy that they are now at least so fair to at least tell this honorable court and also me after I've spent 6 months in
Not at
custody.
least every time he's very.
Well, this reply is for the first time they have crystallized. I'm not saying helping. I'm saying you are being fair and honest.